Good morning. Good morning and welcome to the Bipartisan Policy Center. My name is Janet Marchibroda. I run the Health Innovation Initiative here, and we have a terrific program today. This morning we're going to talk about advancing innovation, competition, and access for biologics through patent policy, and we're going to have a specific focus on therapeutic antibodies. So advancing innovation and accelerating the development and delivery of cures and treatments for Americans has been a big focus for us here at the Bipartisan Policy Center over the last several years. Under the leadership of former Senate Majority Leader Bill Frist and former Representative Burt Gordon, we did quite a bit of work to support the Senate Health Committee in particular as Congress advanced the 21st Century Cures Act. So some of you are thinking, well, what are therapeutic antibodies? What are they? And I thought, we'll get into more detail in the discussion, but basically they're proteins that can be produced by the body's immune system to combat harmful substances called antigens. And these were actually discovered way back in 1975, and it really set the stage for a revolution in medicine. And today, and I know we've got a number of patient groups in the room and online, therapeutic antibodies effectively treat a wide range of diseases, such as rheumatoid arthritis, multiple sclerosis, and several types of cancer. So, why are we here? Over the last several months, the team at the Bipartisan Policy Center, and I see Tim Swope in the back of the room, the team here, the whole team here, have been doing a lot of work in this area. We conducted a lot of research, interviews, we hosted roundtable discussions to examine the role of patent policies in accelerating innovation, promoting competition, and assuring patient access. Those three things were our goals, and having them work together can be difficult sometimes, and we're going to talk about that this morning. I can't think of anyone better to kick off today's discussion about advancing innovation, competition, and access for biologics, for medical products through patent policy than Drew Hirschfeld. Mr. Hirschfeld is the Commissioner for Patents at the U.S. Patent and Trademark Office. For those of you who aren't as familiar, what the USPTO, or the PTO as they're often called, they play a really critical role in accelerating innovation in our country. And what we'll learn today from Mr. Hirschfeld and from our panelists is the PTO is a mechanism that really protects new ideas and investments in innovation and creativity. Anyone can be an inventor in our country, and they're at the cutting edge of the nation's technological progress and achievement. And given all that we have learned about the role of patent policies in advancing innovation, competition, and access to antibodies, we were especially delighted here at BPC to see some of the actions taken by the USPTO over the last month or so. Just last month. This is new information. We think these actions will have a very positive impact on patients, and we hope you'll talk a little bit about that during your time here. Mr. Hirschfeld was appointed to the role of Commissioner of Patents in July 2015, and in this role, it's a very big job, he manages and directs all aspects of the USPTO, including their operations, examination policy, patent quality management, international patent cooperation, which I know is a big topic, resources planning and the like, and we're so delighted that you're here. So everyone, please join me in welcoming Drew Hirschfeld. Thank you.
Thank you very much for the very kind introduction, Janet. Good morning, everybody. It's a pleasure to be here with all of you. I want to start by thanking you for having this discussion on innovation, competition, and access. They are critical components of our society, with, in my opinion, innovation being at the foundation for driving both competition and access. At the USPTO, where we are focused on one sole mission as far as the patent side, not the trademark side goes, but as far as the patents go, we have one sole mission, and that's to issue patents of the appropriate scope to inventors. When we do so, right, we believe we're giving the incentives to people to invent, right, they get a limited monopoly for when you get a patent. They get the incentives to invent, and part of the quid pro quo is that when they get a patent, all of their information will be made public so that others can learn from it and can expand on those disclosures. And we believe that this is a key driver for improving competition, improving access and knowledge and advancement of society. Fostering innovation is the reason many of us, like myself, have dedicated our careers to the patent field. Innovators improve our lives. It's as simple as that. And I will have most of my remarks, I wanted to keep on a more high level than only biologics, because I think the same principles apply. But certainly from a technological and scientific standpoint, innovators create wide-ranging advancements, from new medicines, of course, and new medical technologies that cure illnesses and save lives, to technologies such as smartphones that let us communicate more effectively and efficiently, and there's so much more, of course. From a business standpoint, they drive our economy through the creation of jobs and opportunity. As you all know, I could go on and on. It is literally endless of what is covered by patents, what is potentially patentable, and what has helped spurred our economy. I like to play a game. I used to like to play a game with my children when they were little, and it's the game I'm sure many of you have played. It's when I was your age, I didn't have, right? And if you do that and you think about all the things you didn't have, right, you really realize how far society advances. And in my role, I had the opportunity to speak to a group of young student inventors from an elementary school. And I started off by saying, can you imagine a world without, music on your phone, without even a phone, without having to text? And they were mortified. And then their parents were all smiling because they knew where I was going with that. So that was a fun game. It's a good way to see the impacts of innovation. I'd like to talk about one inventor that I chose for a variety of reasons. It seems that she was the perfect person to discuss today, because she embodies everything that we are talking about, being very innovative, fostering competition and job creation, et cetera. Her name is Carolyn Burt. I believe I'm preaching to the choir when I talk about the wonderful things inventors have done, but let me tell you a little bit about Miss Burt. She invented the field that's called bioorthogonal chemistry, which allows researchers to chemically modify molecules and then observe their behavior within living systems without disrupting or interfering the natural physiology of the living system. Her work enables reactive sites to be introduced into antibodies. These reactive sites can then serve as attachment points for other molecules, such as drugs. The technique can be used in many ways, one of which is to efficiently fight cancerous tumors. Another way is to provide viable treatment against viral infections. This is an inventor who has literally invented an entire new approach to healthcare that is just absolutely remarkable. She's been named on 50 U.S. patents and has received numerous honors and awards, including the 2016 National Academy of Sciences Award in Chemical Science. She's also started a company to commercialize her patented inventions, and last year, which is where I met her, she was inducted into the National Inventors Hall of Fame. She's certainly a prime example of why we need to support and foster the great innovators of our society. Her work is a prime example of innovation helping on the individual level by saving lives and curing disease, and on the macro level by enhancing the economy. Certainly because of her subject matter, I could not resist talking about Miss Burt. It is wonderful what her contributions are. I'd like to now turn a little bit to the USPTO, and more specifically what we can do to help advance innovation. And I'd first like to describe the role of the patent examiner, which I'm not sure too many people fully understand. And then I'll look at some of the bigger policy issues about our guidance, for example, and what we can do. I will mention the changes that we've made recently. But let me start with the patent examiners. And you probably might be surprised to know that we have over 8,000 patent examiners. They examine in every technology you could imagine. I was a patent examiner. That's how I started at the USPTO back in the mid-1990s. It is a very challenging job. Their role is to first look at an invention, make sure they understand it. So they need to be versed in the technology. So we have people in all different technological backgrounds. Once they understand the invention, they need to understand what is being claimed by the applicant as their invention. This is, of course, the legal claims at the end, which control the scope of protection that they would get should they get the patent. And then the examiner has to do a search of related patents or any other prior art to make sure they can see if any of the claims are deserving of patent protection. It can be a yes on the first go, it could be a no on the first go, and it could be anywhere in between, with maybe some claims being patentable and others not being patentable. Once the examiners make that determination, they do an office action, and there's a back and forth with the attorney or agent or the inventor, whoever is being represented. And they have that back and forth until they reach conclusion, hopefully resulting in a patent. Why I'm going through this is because I want to point out that the examiner has a critical role in determining the patentability or lack thereof of anybody's invention. And what's most important is that as they're looking at this, they're making the determination based on issuing those claims as patents that are of the right scope. So what I'm talking about is we don't want to issue patents that are too broad and cover more than the inventor was entitled to. By the same token, we don't want to make the opposite mistake and issue less than they're entitled to. So the role of the examiner is to really mete out what is deserving of patent protection and help the inventor get the patent of the right scope. To put in context what we do, we get about 600,000 applications a year. So it's a very large business. The examiners are all on a production system, so they have to do a number of applications in a certain period of time. It's very tight production system, just to be very, very blunt. The more experienced examiners are given less time, as they're of course more versed in the technology, and the newer examiners are given more time as they need to come up to speed on the technology and also the law. And as you probably all know, technologies are always evolving, and that's of course with the help of patents and others. And the patent laws are always changing, and that will be part of where I'm going to talk about in a short period of time, because it's critical that the examiners are on top of both the law and all of the technology. So I'd like to go back to Ms. Ozzie, the inventor who I just mentioned, and share a statement that she made in her National Inventors Hall of Fame speech when she was inducted. And to me, her quote is critical because it puts into perspective the role of the patent examiner. And specifically, she made the point of thanking the examiners, saying the examiners, she said, I'd like to thank the unsung heroes at the USPTO, for example, the patent examiners. Without the patents and the intellectual property system, there's no way that we can make the investments we make of our time and resources that need to be amassed to bring these inventions to life, excuse me. So I owe the USPTO a great debt of gratitude, end of quote. And while I appreciate that from a personal perspective, and I told her after she became my new best friend with that quote, the way she praised the examiners, what she's really praising is the examiners, but the patent system as a whole. And she really points out that she couldn't have made those investments and couldn't have achieved the success that she has achieved and the advancement that she has achieved if it weren't for the patent system, which gave those incentives for her to then get to do the research, get the patent protection, and then her idea, of course, as I explained earlier, is now out where others can see it, learn from it, and even improve on it and seek their own protection, and the cycle continues. So as an aside, I'm leaving right after I am done with the panel here to go back and participate in a ceremony of our newest primary patent examiners. These are the patent examiners that have achieved the ability after years of work to sign their own office actions. So I'm literally walking off of this podium onto that podium for a wonderful celebration. Those examiners have all spent around 5 to 6 years of time at the office as an examiner, learning their trade, and they've gone through about 1.5 years worth of rigorous testing to make sure they are well versed to make those difficult decisions that patent examiners have to make. So that's a fun thing for me today. I'd like to transition now to the broader picture and look at USPTO examination guidance. As I said, the heart of what we do is we examine patents and try to help inventors obtain patents of appropriate scope. And I'd like to turn to the guidance. On a larger scale, the guidance is how the USPTO seeks to maintain as much predictability and stability within the framework of the patent statutes and the case law. Reliability and stability are one of the main goals of our new undersecretary, and his name is Andrei Iancu. And for those of you that he's been at the PTO for about 1.5 months now, to 2 months or so, and for those of you that have heard him speak or even saw his confirmation hearing, those words, reliability and predictability, are words that he continues to repeat. It's his view, and I certainly agree with this wholeheartedly, that the more reliability and consistency and stability in the patent system, the better we all are. That's true whether you're talking about examination or whether you're talking about once a patent is issued. We all need to understand when a patent will be valid. We need to issue patents that are valid. So he's very focused on this particular topic. And one area that he's focused on, of course, is our examination guidance, which is used not only by examiners, but also by the public at large as they are evaluating their situation. So we have attorneys and even potential competitors that look at our guidance to make sure they can make the most educated decisions about their next step. For an example, an investor can choose to invest early when he or she knows how a particular innovation will be examined, and they can recognize their chances of success during the patent prosecution process. So I and my colleagues at the USPTO are working with Director Iancu to improve our examination guidance with an eye towards increased reliability and stability. For those of you familiar with the patent laws, I'm sure you'll recognize that this is a very challenging task given the significant changes to the patent law in the last several years, particularly with regard to one area that I'd like to mention, that's subject matter eligibility, which is one of the 4 main statutes that an examiner needs to apply. On this eligibility front, in recent years, we've had numerous changes in the patent laws stemming from Supreme Court decisions that have greatly altered the type of inventions that we consider eligible for patent protection. The decisions have impacted inventions in a whole variety of fields, and I know this is much broader than you're all here for today, but they've affected business methods, software, isolated genes, personalized medicine, and diagnostic methods, just to name a few. So for those of you that are aware of these decisions, you'll recognize that it's extremely challenging to turn these decisions into examination guidance that can be applied in a consistent and repeatable manner. not only are there numerous interpretations of these court cases, but the law has been evolving over the last several years and continue to evolve. And what that means for somebody like myself is, as we are trying to make sure that our 8,000 plus examiners are trained and being trained in laws that are evolving as you're trying to train them, you can imagine the challenges that creates. And again, we have about 8,000 plus examiners. Under Director Yanku's leadership, we're looking for ways to improve our guidance so that we can best foster the innovations of our greatest minds. I'm very confident we're up to the task. I do believe anytime there's a change, there's always going to be a little bit more disarray before things start to calm down. And I believe we're going to turn the corner, and we're going to make sure that we improve our guidance. And we're looking for every opportunity to do so. I wanted to point out that should we decide that changes in any of our guidance, we'll proceed, and specifically in 101, that's a subject matter eligibility. We'll proceed as we have done in the past, where we seek public comment on our guidance. For those of you that are familiar with our guidance, we've actually gone through multiple rounds of public comment where we receive input from the public and then amend the guidance as we see fit, responsive to the comments, and then have even come out with additional requests for comments. This, of course, enables us to reap the benefits of all the great minds that work in the patent field. So if I leave you with one task and one ask of all of you, it's that you continue to engage with the USPTO, particularly when we're seeking public comment. It's critical that our policy decisions are best informed. The more people that weigh in, absolutely the better. So my ask of all of you is that continue to monitor what we are doing at the USPTO and let us know how we are doing, and give us your comments about potential changes or improvements that we can make. We find that extremely helpful. And my additional ask related to that is that this is true whether you agree with what we're doing or whether you disagree, because by human nature, you often get comments when people disagree. And what happens is if we get all the disagreements and then we make changes, and all the people who agreed with the original position say, hey, why'd you change that? Say, we didn't hear from you. So I think it's very important that we hear from all sides so that we can make the most educated decisions that we can. I do want to discuss the memo and the recent changes. These were based on a Federal Circuit case. This memo relates to changes in our examination guidance based on a CAFC decision, a Federal Circuit decision in Amgen versus Sanofi. And this deals with what is needed to adequately, properly describe an antibody in a patent application. If it's not adequately described, just like anything else in the patent laws, if they're not adequately described in a patent application, the application would get rejected. So this case clarified what is needed to adequately describe an antibody. Feedback we've received at PTO is this has been a very good change. The change, not to get too technical, but the change is about you now need to describe the antibody itself. There were some examples that we had given that date back, I think, to 2008 at the PTO, where we had said if you're describing if you identify and describe the antigen, that would be enough for people to understand what the antibody is, so you didn't need to describe the antibody itself. That has been changed by this Amgen decision that recently came out, and so we've amended our guidance to examiners that now state that proper disclosure or proper description of an antibody is of the antibody itself. And where I think this will be helpful in the feedback we've received is that this will have more stability and reliability, getting back to use Director Yanku's words, in the disclosures, so people can understand the scope of those disclosures and what protection is being covered by the resultant patents, and will help help potential competitors, et cetera, understand what the scope of the invention is. So I'd like to mention one other topic before I conclude, and it's not specifically related to guidance per se, but it is about public input. I've mentioned a few times Director Iancu and his arrival at USPTO. And I've also mentioned public comment. I wanted to mention that he has been spending his initial many weeks at USPTO by meeting with members of the public and groups from the public to hear their thoughts about USPTO. And this is less formal, say, than we have, a formal request for comments on a set of guidance, for example. But nonetheless, he has been having numerous meetings to get stakeholders' views of areas that we are doing well at PTO and areas where people suggest we should be making changes. I think this is a really good step for all of us at USPTO to be getting this input. One area that he has been fielding a lot of information about is our Patent Trial and Appeal Board. There are many who believe that the trials, we call them the AIA trials, the American Invents Act trials from 2011, created new trials at the USPTO where patents can be challenged. And it's a relatively new process, again, dates only back to 2011. And there are many people who are suggesting that this is an area of focus for the USPTO to be looking at. And Director Iancu is certainly focused on that area as well, in addition to our guidance, and is listening to many people and their views on what potential changes that we could make. So in conclusion, I want to thank you all for furthering the discussion about innovation, competition, and access through patent policy. I'm, of course, a strong believer that the U.S. patent system has been and will continue to be a pillar of U.S. progress. This summer, we are going to issue the 10 millionth patent, which is a great milestone. It's quite an achievement and a testament to not only our innovators, but to our patent system at large. I've been at the PTO long enough to see some of the million milestones cross over, and the 10 millionth is certainly the biggest milestone that we've hit in issuing patents, and that should be sometime this summer. There are certainly challenges that we all need to address, like there are and always will be for any complex system. I'm confident that we are tackling and have tackled and will continue to tackle these challenges, and the system will remain the great force that it has been, and it will continue to spur our country. With the help of all of us in the patent ecosystem, the Carolyn Burtozis of the world will continue to move us forward. With that, I thank you very much for hearing my remarks and for having me here, and I'm very happy to take some questions if any of you have them.
Thank you. Questions for Mr. Hirschfeld, and I think, please, if you'll share who you are, and I think we've got a microphone. Here we go. Thank you.
Hi, Stacy Burgess with Veterans Vision. I was wondering, what do you do as far as the drugs that do have patents and that are off-labeled? Would those people lose their patent if it caused like massive deaths or contributed to suicides or homicides or what have you? What do you do when the drugs should be taken off the market? For example, like schizophrenic drugs that are off-labeled to men, women, and children for autism and ADHD or stress, and not telling the patient this drug is actually for schizophrenia. Can people lose their patents for false advertising or misleading the public?
So I'm going to limit my response to what my realm is and discuss at USPTO. The ways that you can lose a patent and the patent protection would be from challenging the validity of that patent. Now, it could certainly come from a misstatement that has arisen during the prosecution of that application. So if the examiner were misled in some way, that is certainly a possibility. But as for a patent being awarded and subsequent to its issuance, creating effects that weren't foreseen that have a negative impact. To me, that wouldn't result in the negation of the patent, but it might have other consequences, of course, about the marketing and use of that patent.
Other questions? Okay. Oh, here's a gentleman here.
I can just. Okay. Hi, Zach Sentimentus with the Young Trade Professional. So given today's global marketplace where you have a substantial number of accusations of other countries stealing America's innovation, what are your thoughts on kind of creating, and you see a lot of legislation in Congress right now, like the Stronger Patents Act, pushing for stronger patents. What do you see as kind of clear-cut legislation to help kind of restore balance to America's patent system for innovators and creators? Thank you.
So in my opinion, any legislation that would really help the system would, and I am going to take Director Yanku's phrase, but would really increase the stability and reliability of the patent system. So I'll take, for example, the subject matter eligibility that I spoke about in my remarks. There have been a lot of discussions about whether legislation is needed there. Certainly, it is an area of concern and confusion, leading to a lack of stability. That would be one area, for example, which legislation, if it could move forward, I know there's people on all sides of the issues, and that's what makes it challenging, but if legislation could move forward, could certainly help in stability. Your question about the international front raises a lot of other questions and issues, and they relate to changes in standards and examination practices in different countries. We actually are piloting a number of programs to address some of these concerns. Some of the programs that we have actually will have examiners, and they're small pilots because this is just an initial phase, but they actually have examiners from the U.S. Patent Office, so examiners that work for me, of course, who will work with examiners in other countries who are examining related applications. And what they'll do is they all do their own search that I spoke about, but they'll all actually share their results before they proceed with an office action to the applicant. In that regard, we're hoping that the best prior art gets in front of the examiner, and there's consistency as much as there can be through the different countries. And then with the best prior art in front of the examiner, they can make the best decisions about patentability and issue the strongest patents. And I think there's a lot of potential gain. I know you asked about legislation, but I think there's a lot of gain by continuing to evaluate and expand these opportunities for inventors in one country to be working with inventors in another country.
I think we have time for one more question, and we're delighted Mr. Hirschfeld is going to join us for the panel discussion, so we'll have more time. Maybe two quick questions, okay, and then we'll move to the panel.
My name is Paul Eiding with the Blue Cross Blue Shield Association, and my question is when the PTAB process goes through and finds that some patents are found invalid, how does the PTO review how they had originally issued that patent and how the same system has invalidated it in terms of to avoid that type of pattern in the future? Absolutely, and it's a wonderful question and something we obviously have been focused on since the start of the AIA trials, as it's a whole new body of information that we didn't necessarily have before that we do have now. We attack that in a number of ways. First, of very recent start, we have examiners have access to in their applications, we've added an icon and a link that gets them access to any related cases in front of the PTAB, so that they're aware of the issues that are going on at the PTAB. So you wouldn't have an examiner examining in a vacuum and the PTAB considering a similar case, and they're not aware of each other's actions. So that would be helpful. It didn't exactly answer your question. Additionally, what we do is we have
an evaluation being done of decisions at the PTAB and look to see in those decisions what were the reasons why, if to the extent they found something different than the examiner did, we are currently evaluating those reasons. For example, we're looking to see was prior art in the case that wasn't in front of the examiner, and if so, where did that come from? Was it a claim interpretation? Did they think that the claim interpreted a different scope? Or was it that the laws have changed and that the examiner made the right call when they were examining? And all of these factors play in to some extent depending on the situation. But we absolutely are and will continue to expand the feedback loop from the PTAB trials to the examiners. I'll also just point out that that Director Yanku has also, as he has come in, focused on this area as well, and we'll be looking to see what we can do to even further use the teachings back and forth.
This gentleman.
Thank you very much. David Greeley, I run a nonprofit organization, American International Health Alliance, which happens to be on the second floor of this building, that focuses on health system strengthening in the developing world. A more high-level question as well. As you know, patents and protecting intellectual property is not universally seen as a good thing. Only look at HIV and AIDS 20 years ago and how that whole thing has exploded in terms of people saying that patents are actually part of the problem rather than the solution. But I believe, of course, that patents are critically important. What role can the PTO play in really making the general public, including in countries outside the U.S., understand the real importance of role that patents play in improving lives and accelerating access to health and to medicines? Does the PTO have a role? Can it be more forceful? Because again, it's not something that is universally accepted as a good thing.
We absolutely do have a role. Thank you for the question. I deliberately chose to focus a fair amount on the examiner's role. Because at the heart of what we do at the USPTO are the patent examiners. And by having them make the best decisions that they can, that issue patents of the appropriate scope, patents that can then achieve the right incentives and can foster innovation, to me, that's at the heart of the system. And the more that is done correctly and well, the better the information everyone will have about the system. We also have a education component, which I think is very important. We have an Office of Innovation and Development directly focused on outreach and communicating with people about patents. And I also believe our regional offices, which are also a 2011, they were initiated in 2011 with the American Invents Act that I spoke about, have been used for educational purposes and a lot of outreach, reaching much further than the Beltway. And so I think all of this together is a way for us to help educate on the role of patents, and events like this, coming to and speaking with and participating in, are critical to our success.
Thank you so much, Mr. Hirschfeld. Please join me in thanking Mr. Hirschfeld. And he has agreed to join our panel, so we're delighted that. And with that, I'd like to invite our panel to join us on the stage. And while you're making your way up here, I'd like to introduce each of them. So on the right of Drew, on Drew's left, we've got Mark Boutin, who's the CEO of the National Health Council. And Mark and the National Health Council have been a leading voice for greater patient involvement at every stage of the healthcare continuum, starting with the development of new drugs to regulatory oversight of healthcare delivery and shared decision making. We're especially pleased, Mark, that you're here because he partnered with us and played a critical role in our advisory committee as we were working on the 21st Century Cures Act and informing and supporting work there. So welcome back. It's great to have you. On Mark's left, we're pleased that Oscar Levac is with us today. He comes to us from Cornell University Law School. He's a professor of law there, has a PhD in physics, focusing on techniques for determining protein structure, and he also received his law degree from Yale. And then part of his background, he was a postdoctoral scientist working on physical realization of quantum computing in the Quantum Information Group at IBM's Almaden Research Center in California. And then finally, we're so pleased to have Gil Voy with us today. He comes to us from Indianapolis, flew in. Gil is the Vice President and Deputy General Patent Counsel at Eli Lilly and Company, and he's been with Lilly since 1994. And his practice within Lilly's legal group has spanned all aspects of things like patient procurement, litigation, transactions, and administration, as well as counseling Lilly's oncology business unit. And as a co-author of a representative number of amicus briefs, that's, for the patent attorneys in the room. Gil has been active in efforts to shape the legal environment governing pharmaceutical drug discovery and development. So that's our panel. And I thought we'd get started. Mark, you're so good at sort of laying the foundation for discussions. I wonder if you might talk about the role of intellectual property, IP, protections, or patent policies in supporting this notion of innovation, competition, and patient access when it comes to medical products generally, Mark, as well as biologics. You might set the stage for us.
Sure, Janet. Let me start by thanking you, Janet, and your team, Tim, and all the other folks that worked on this issue. These issues are critically important to all people with chronic conditions. And I think sometimes we forget because the complexity of this issue is largely ignored and often taken for granted. I just wanted to set the stage a little bit by saying that I've been a patient advocate for more than 25 years. I actually have a British law degree, had lived abroad since I was 13, and was about to start working in the European communities when, over a period of just a few short months, everyone in my family was diagnosed with one or more chronic conditions, which ranged from heart disease, cancer, neurologic, autoimmune, HIV, and some others. I ended up moving back to the United States, settled in Boston, and worked in a law firm and volunteered with a number of patient organizations. And then over again, a relatively short period of time, all these people lost their lives, either because there were no effective treatments or the treatments were ineffectively deployed. We in the patient community have a huge stake in ensuring innovation. And I want to start by making 2 points as part of this stage setting. One is, I'd like to ask the audience, what is the most important invention in the history of man?
Wheel.
What's that?
The wheel. Wheel. The wheel.
The wheel? Any others?
What?
Don't be shy.
Penicillin.
Yeah. So you hear a lot of different things. I mean, if you ask some of our younger millennials, they'll tell you it's a smartphone. But it could be could be the computer, it could be electricity, it could be the light bulb, it could be what came out of the Industrial Revolution, even what came out of the Renaissance. The interesting piece about intellectual property is it's been around for centuries. It dates back to 500 BC. The Greeks had intellectual property for anyone who would improve a luxury. They would get a year of protection. This is not a new concept. So that's number one. It's been around and it's driven where we are today in society. It's a critical piece of everything that touches our lives. And for the more than 150 million people in the United States living with one or more chronic diseases, it has driven innovation to where we are now. And in fact, 10 years ago, when biologics were coming into the market, people thought they had to deal with mostly treatments that dealt with their symptoms. And you started to see biologics fundamentally alter their lives in amazing ways. Now we see gene therapy and other interventions coming through that may be a one-time only treatment. That was science fiction 20 years ago. This is not a new concept. It's an ancient concept that has driven society the way we are today. The second point I'd like to make is this evolves. In 500 BC, you got a year of protection. Now for patents, you get a lot longer. There are different forms of intellectual property. There are different forms or protections to drive innovation in health. We as a society have to constantly look at our systems that are driving innovation and ensure that we get the balance correct. Because I can tell you, for the members the National Health Council represent, which are many of the patient advocacy organizations, and several of them are here in the room today, there are many, many conditions, in particular in the rare condition space, for whom there are no effective treatments. They simply get sick and die. Even for some very common diseases like Alzheimer's or ALS, no interventions medically that are going to save or prolong your life. We have to constantly look at our systems and decide what is the right balance between innovation, but also access. And I can tell you, when I speak with the CEOs of the patient groups in membership at the National Health Council, and we've been doing listening sessions, to the organization, to the CEO, every one of them will say, right now, my biggest concern is access to care. And with access comes affordability. You have to get that balance right. And I can tell you the pressures are tremendous. We see less money going into health innovation. And at the same time, we see people who are of lower socioeconomic status, even people of middle class, not getting access to the high-value interventions that exist. So again, not a new concept, but we as a society have to decide what that right balance is to promote innovation and promote access. And that evaluation is ongoing. And I think we're at a really interesting time in our history right now. So I'll stop there.
Thank you, Mark. Thank you, Mark, for those insightful remarks to start us off today. Gil, I wonder if you might offer your insights, the balancing innovation, competition, and patient access from a research and development industry perspective.
Sure. And first of all, thank you, Janet, for inviting me to the panel today, and Tim and all the work that you've done. It's very important. A patent system as a means to promote innovation, of course, is very important, as already sort of been discussed. I don't need to convince, I think, you, Mark, of that, or any of the rest of the panelists. The trick here, or the key is the balance of coverage, of scope. So you want to have a robust, reliable patent system, particularly when the cost and time associated with making an invention are grossly disproportionate to the cost and time it is to copy that invention. The appropriate grant of patent coverage allows a period of time for an innovator to have exclusivity around their product. Exclusivity meaning there isn't a cheaply developed copy of the product on the market. During that period of time of exclusivity, the innovator has time to recoup investment. The investment is used to perhaps further study the existing invention and prove it. In the case of antibodies, that additional investment can drive new antibodies. So it's critically important to the ecosystem to have reliable protection around disclosed inventions, disclosed antibodies. Part of the high cost, if you will, is associated with developing a drug is, of course, the appropriate regulatory burdens that are placed on a pharmaceutical company to prove the safety and efficacy of a drug prior to putting it into widespread medical use. A second structurally unique antibody that comes to the table is not going to get a break, if you will, in the regulatory process of proving its safety and efficacy. So a second structurally unique antibody, structurally different drug, is going to have to prove itself independent from the antibody that came before it. So when you have a patent system that may inappropriately award patents to the first innovator, where the first innovator's claim scope, this is talked about Deputy Hirschfeld, where the claim scope is broader than actually what was disclosed through the patent disclosure, you may find that the second innovator, the second antibody, having a legal hurdle to being able to make it to the market. In a best case scenario, if that were to occur, the second innovator would essentially have to pay a tax to the first innovator for access to the patent. It would be a license fee, for example. In a worst case scenario, and this is a different picture on access, maybe the word access meant something different to most of the people in the room, but in a very real sense, the first innovator with the inappropriately broad patent could completely block the second medicine from reaching patients at all. That is really a high-level access problem. So, bottom line, I think, is yes, we need a very robust, reliable patent system to protect disclosed inventions, but we need to be careful that the coverage that's granted doesn't go beyond the scope of disclosed invention and thereby inhibit proper subsequent innovation.
Oscar, I wonder if you might weigh in as well. You've been studying patent law for a long time, particularly around emerging therapies. Any insights to add on this balance between innovation, competition, and access?
Well, I'll try to add to what Mark and Gil have just been relaying. And that is, certainly the IP has been around for a long time, but the controversies around IP have been around almost just as long. And so this is not the new area. And what's in many ways very interesting is that we haven't converged on what is the right solution, and that we're still debating and trying to sort out what is the proper balance. Famously, you had someone, Thomas Jefferson, writing a letter to a disgruntled patent applicant taking on the role before we had a PTO, but explaining very eloquently what's very interesting about ideas. And he had this, he did it far more eloquently than I'm about to do, but talking about a candle that can then be passed to someone else with a candle. My candle can light someone else's, and this thing can spread in this very interesting way. And so you have this access notion right there before you. It's like, we have a good idea, a bright way to do something. Everybody could share it. But then that immediately leads to the question of, well, how are private entities going to be able to pay for this if it turns out this is something that can be copied easily once it's been created? And that's, Gil was talking about these expenses, and you have the R&D that goes into it up front. You have the FDA approval. It can be extremely expensive. And that's just talking about the one therapy. But what about all the other ones that failed? Right? You have all these failures. And so you have this huge amount of money that needs to be made up. And so then we have to have some system in place to provide exclusivity. But at the same token, you have the patients who would like to have access to it today, saying, well, wait, Jefferson was saying how easily this could spread. I could make this very cheaply, and I could save somebody today. And how are we supposed to make that balance? And it certainly is something we're still wrestling with. So, Janet, I can just relay the difficulty. I don't have any great insights. This is a debate that we've had for a long time. But to add to Gil's point, you do have you balance. You have the initial inventor with a patent, and we're going to talk more about scope. There you have this issue of inventor with a certain scope, and you can imagine that preventing or maintaining a high price that's hopefully going to recoup some of those R&D costs and those regulatory costs. And so that's a balance between the patients today and the inventor today. But just as Gil was saying, there's these future issues. If the patents are broad or too broad, then future innovators are just going to not be allowed in. The fencing is too wide, and that impacts future patients who would have said, well, the current therapy was okay, but actually, if we had had more competition, maybe that would have driven down price, but we would have had another choice, and maybe I'm the kind of patient who that other therapy would have been better for. And so there's all this goes into the mix, and it's something that certainly needs to be worked on. We haven't solved it by any matter, but it's something that we're hopefully converging towards better solutions.
Drew, thank you. Drew, you've shared with us the PTO's role in fostering innovation, particularly for life-saving treatments, and thank you for that. I wonder, as you're hearing the conversation, anything to add on this notion of balance from your perspective?
Yeah, a few points. I think first, I agree that balance is the key word, right? I think you need to and I don't want to repeat too much, but what can't be lost in that balance equation is the incentives to innovate, because if as was said by other panel members, if people don't have the incentives, you can have all the access you want, but the access that you'll have will eventually be outdated, and we won't have the advancement that we all need as a society. So balance is certainly the key word. The only other point that I'd like to make is there's a discussion about, which I agree with, about scope being too broad. If we issue a patent that has too much coverage, it's too broad and covers too much, it could wrongfully preclude others from entering the market. But the converse is also true. If you issue a patent with a scope that's too narrow from what an inventor, an innovator rightfully deserves, then they're not going to be able to reap the incentives that they should be getting. And that gets me back to the word balance being the key. And part of what I believe is critical for people like myself and the USPTO is to make sure that we're finding that Goldilocks approach of the scope, and making sure when you issue patents they are of the right scope, and that is the million-dollar question, so to speak.
So I'm looking at our time. We're going to dive a little bit into the detail now. And a number of you and folks online have reviewed the report, or the policy brief that we released this morning. And Gil, I thought we might start with you. As we indicate in our report, so typically, and as Drew mentioned in his remarks, the PTO generally requires applicants to provide a full written description of their invention for all the reasons described, but it made an exception to this rule several years ago when it comes to therapeutic antibodies. Could you talk from your perspective around why the PTO may have made the exception, and why it no longer makes sense, as outlined in the PTO's memo released about a month ago?
So I don't know if
recognizing we don't have, how many patent attorneys do we have in the room? We've got a couple, but
yeah, so I don't know that the PTO set out to make an exception. The way I sort of rationalized what happened was, if you go back actually to the late 90s, when the well-characterized antigen test for written description was first proposed, back in the late 90s, DNA, therapeutic proteins, antibodies had just started to become recognized as very important in healthcare and drug discovery and development. And at that time, the science had not yet evolved to a point where characterizing these large chemicals, basically, an antibody is a large chemical. The technology just hadn't gotten to a point yet where characterizing these things was easy for inventors to do. I think also a thread running through that was that some people were worried that if an inventor were required to include too much structural information about what their biologic material was, that it would be too easy for a second person to come on and essentially copy the invention, but yet avoid the patent. So what I think what the Patent Office tried to do was to look at, there's another requirement beyond written description. It's called enablement. We don't have time to get into it. But I think a theory was that if an applicant could sort of provide a description in the patent application that enabled the invention but didn't describe it, that might be an okay way to satisfy a written description. It certainly, I can sort of rationalize it today, but at this point, the methods of characterizing biologic materials have greatly improved. And point of fact, there have been subsequent developments in case law that make very clear that a written description requirement is a separate requirement from enablement. And just because you may enable something doesn't necessarily mean you've described it. And I had a nice example that I could have used, but I think we're a little short on time to sort of flush that out. But I'll go ahead and cede.
Thank you. Oscar, you've talked, in your research, you've talked about the notion of broad claims, reading some of your papers, and their impact on competition in the market, including the impact on emerging therapies that we've talked about this morning. I wonder, again, for the non-attorneys in the room, can you describe what you mean by broad claims? Maybe provide an example or two and describe, how one could address the situation.
Well, I'll see what I can do. And this might be where Gil was alluding to. There is this, to try to understand what broad claims, we were talking before, and Drew was mentioning sort of claims broader than someone's entitled to. So we're not talking about sort of the absolute size of something. It's absolute, or the size of the exclusivity that you get relative to how much you've disclosed, or I would say how much you've invented. And that can depend on the area of technology, and that's what's interesting here. I'll try to give an example that hopefully is illustrative. Some guy walks in and says, I've invented this, right? You might have one right in front of you right now. You have a cup and a holder, and says, I've invented this. I'd like to apply for a patent. And the patent attorney smartly says, well, okay, that is this object you've built, and I see what you're doing here. You're trying to protect someone's hand. This is made out of cardboard. Does it have to be out of cardboard? And the inventor would say, oh, no. The whole point was that it's an insulator. And you say, all right, well, let's write that down. Let's describe this in great detail, but let's go on and say, look, it's not important that this was cardboard. It needs to be an insulator. It could have been made from all sorts of other materials. And in fact, I can tell you exactly what it needs to do. It needs to insulate the hot from the liquids inside and keep my hand from getting discomfort from the heat. And so, what's interesting there, we're talking about broad claims. Here you have an object, and then you have somebody disclosing in broader detail various different alterations. And that's sort of the invention. And in that area, when we're talking just about the disclosure requirements in U.S. patent law, then we'd say in that example, you could claim relatively broadly because you're able to understand what's going on here and describe it in great detail. Other areas are different. And so this is sort of an interesting sort of history of science. We don't have any incandescent lamps, I think, here, but there's a famous case from the 1890s about incandescent lamps. There was a competitor to Edison. They're coming up with filaments that were going to go into incandescent lamps. And they'd come up with the idea that if you they used carbonized paper. You could put it into an evacuated bulb, put some current through it, and it would glow for a certain amount of time. And they applied for a patent for it. And you could imagine the same story. They walk into the office of a patent attorney, they have their bulb and say, hey, this is my filament, I would like to get a patent on it. And then the patent attorney's like, okay, well, how else could you solve this problem? What variations on this? And turned out they actually tried to claim quite broadly in the patent, but they weren't able to disclose anything else. They said, well, we did this by trial and error. We don't actually know why it works. This does work, but we can't really provide you with any discussion of other materials that might work. And so it turns out they did try to claim more broadly. The case went all the way up to the Supreme Court. The Supreme Court ultimately invalidated that patent or that broad claim, said you've gone too far. Right? You've gone beyond what you've invented. You've gone beyond the stuff that you've been able to visualize or conceive in your own head. And so what becomes interesting is we can talk about the breadth of claims, but it depends often on the details of the technology. And you do have at least, there's various things that go into it, but one can imagine a spectrum between very predictable arts, where you can very much predict what other materials might be useful for this, to trial and error, like something like the filaments in the incandescent lamp patent case, where with trial and error or serendipity, you can't visualize anything else. And so that the question ends up being, with monoclonal antibodies, where are we on that spectrum? And are we getting it right? That's my best explanation of this.
Drew, I know you had the opportunity to talk a little bit with us about your recent clarification or guidance, update to your guidance last month. I wonder if you might, we discussed it a little bit in our report. Any other details you could share for folks in the room and online?
Sure. I think, I can't go back, and I don't know exactly what in 2008 were the deciding factors, but in speaking to people at that time, I think it was accurately characterized that it was not an attempt to create an exception to written description. Rather, it was that the feeling was at that time, given the state of the technology, that it was appropriate to that you would understand what an antibody was, and that would be properly described if the antigen were identified. And as technology has evolved, excuse me, as technologies have evolved, that proved to be untrue. And then with the advent of the Supreme Court, or the Federal Circuit case, excuse me, where they clearly stated, no, for a proper description, you need to describe the antibody itself. That was the genesis behind the memo.
Thank you. Thanks. I'm looking at our time. I want to be sure we leave enough time for questions. I'm going to switch gears again. So Drew talked about in his remarks how important it is for all of us in the public, patients, industry, others to provide input. And Mark, National Health Council has done so much in terms of providing input and being a voice for patients to what goes on in Congress and the administration. Can you talk a little bit about that? And how it might apply here, and then I'd love to come back to you, Drew, and maybe expand on some of your remarks.
Sure. The patient community has been active in this space for many, many years. The evolution has been quite robust, even in our lifetimes. If you think of the creation of the Hatch-Waxman Act, that was clearly a congressional sanctioned compromise between how patents are used and how we provide access to generics. Something the patient community was very much involved in, very much appreciated. The creation of the Orphan Drug Act, while not patent law, created exclusivities in the market for products that treat rare diseases. Again, another balancing act done at the congressional level. We've worked with FDA and HHS on the implementation of those activities. The biosimilars legislation a decade ago was another opportunity for a compromise between patent law and exclusivities. The patient community led an effort called Dormant Therapies to drive the creation of a new pathway for products that didn't qualify for a patent, but had good social utility. And think about that for a second. Patent law is a relatively technical area of the law. There's no requirement to get a patent that it be useful for social good. Clearly, that's part of the intent, but there's no requirement. And there are, in some instances, or by some estimations at NIH, hundreds of thousands of potential medicines that could now be developed as science has evolved that could address unmet medical need that currently are not able to get a patent. That's something the patient community cares a lot about. So we have to think about how we drive social utility in this space. And I want to make just two real quick points. I know we're running short on time, but one is this. About 2 years ago, the National Health Council evaluated nearly 200 proposals that looked at how you can drive healthcare costs down. When we evaluated those proposals against a patient-centered framework, we ended up with about 50 different kinds of proposals, because we eliminated all the ones that said they would reduce costs by eliminating care, not very patient-centered.
Yeah.
But when you looked at the policies that were left, there were only a small handful, and we evaluated them for ones that had data to demonstrate whether or not they could actually drive down costs. The one area where there's great data is when there's competition in the market.
Yes.
And I want to underscore that when you have a patent that is overly broad, and again, I don't think anybody's blaming the PTO for this, the environment evolves. And it's evolving incredibly fast. When you look at the rate of artificial intelligence, science, where we're going in the last decade is completely unlike where we were a decade before. So we have to recognize this evolution is going to continue, and we need to be willing to step up and say, when it's overly broad, and it's going to eliminate other products coming into the space to treat that condition or related conditions that give you the potential to have better or different treatments that meet your medical or personal needs and drive down costs, we need to get that balance right. Constant evolution here as we move forward.
Before we go to Drew, Gil, I ask you the same question. Like, how does industry engage with the PTO? Is it just when you have an invention, or are there other ways?
No, I think the PTO and industry engage with each other actually quite well through partnership meetings, for example. Okay. There has been engagement industry with the PTO on international harmonization issues, for example. In theory, a patentability outcome in the United States should be similar to the patentability outcome in Europe, in Japan, for example. But if that's area, frankly, where we could actually do a better job together in influencing policy, because unfortunately, at the European Patent Office, the patentability decisions on antibodies in particular actually can be quite different than outcomes in the United States Patent Office. Ironically, it's sort of relatively easy at the European Patent Office to get some of these very broad claims, and broad in the sense that it's beyond the scope of the disclosure that's in the patent, because broad isn't necessarily a bad thing. It depends on what's disclosed in the patent. That it can be much easier at the European Patent Office to get broad claims, and appropriately broad claims, than it is to get a claim on an individual, fully defined, fully characterized antibody. So it's an odd place to be, I think, for that. The solution is not to bring U.S. in line with Europe. The solution is to try to influence Europe to get more in line with the U.S. Position on this. So that's an area where we have worked together, and it's an area where I think we could definitely do more.
Drew, we were so we were delighted to hear about all the work that you do around getting public input. And I would say, we do a lot of work in this area. We work with a number of groups across the healthcare spectrum. And my guess is many are unfamiliar with how to provide input. Like, any advice for us on how we can support you?
Sure, thank you for the question, and thank you for the plug on the partnership meetings, because that is a great way to support us. In recent years, we've really tried to increase the number of partnership meetings, and let me tell you a little bit about those. They are basically usually technology-based, so a particular area of the USPTO, such as our 1600 Technology Center, which handles biotechnology, has one of the longest standing partnership meetings that we have, but they're in every technology. They will have partnership meetings that get advertised in advance, and basically the agendas are joint agendas from USPTO and the public, based on input that we've received, and they try to address issues particular to that technology and the examination process relative to that technology. And it is a great way for us to have an informal back and forth in these partnership meetings. If for those of you, if any of you haven't gone to any of them, I certainly would urge you to look them up. I always get wonderful feedback about the partnerships. We've actually gone from having 2 or 3 a year to last year, I believe we had 12. because we've tried to, again, expand at least to every technology. Some areas are even having 2 a year. So they've been really helpful. That would be one way to engage. Another way, and this gets back to the guidance when we issue, is when we issue a significant change in guidance, or even larger policies, we usually do so with a request for comments, and they're published in the Federal Register and the Official Gazette, and they seek comment from the public. And basically there would be usually a comment period. Sometimes we always accept comments and we just say we're open for comments all the time, but in particular issues, we'll have a period where we'll ask people to give us feedback. One of the tricks for us, and I know we're out of time, one of the tricks for us is as we're getting comment, we also have 8,000 examiners looking at 600,000 patent applications a year. So there's always that balance of where they should be in this loop. We usually end up coming out with guidance, put them on the guidance, and get comments, and we'll adjust as needed, rather than, it's very odd to have the PTO saying, we think the guidance should be this, but examiners don't follow it now. That's a very odd situation. So we will get comments, and I will tell you, in recent years, we've had this situation, and we have made changes responsive to the public feedback in certain areas and come out with new guidance responsive to that. So that is a way. I'll also just say one way to get apprised of all of this information, whether it's partnerships or Federal Register notices, is to go to our website and sign up for, and I don't remember the exact name, but it's just you get automatic notifications. You can put in your email address and you'll get an automatic notification of events that are occurring at PTO, so you'll become apprised of everything that you could give feedback to.
Thank you. Thanks very much. And I know there's a lot of interest here. We've got a few minutes. What I'd like to do is turn to our audience to see questions for our panel.
Hi, Stacy Bridges, Veterans Vision. I'm concerned about a patent for cannabis, 6630507. I believe it is. You always speak, and I hate to always be the cannabis girl, but you talk about innovations and wanting to get drugs on the market that actually help, and there has been studies that's been done for the past 50 years. NIH has actually given tax money to Israel to study the effects of cannabis. I asked this question as a representing veterans, because we've got 22 veterans committing suicide and 1 soldier committing suicide every day, and they're taking a toxic cocktail of meds, and these meds can have horrific side effects. Is there a pay to delay to keep drugs like cannabis off the market and out of the hands of the people who want it, because it is a weed that anybody can grow and it may affect your sales or your your profit shares? I mean, people are literally dying for a cure. What do you have to say about cannabis and the vilification of that natural plant?
That's a challenging question. A lot of parts of the question. So, we at the Patent Office need to apply the laws to every application, and part of what we don't do is have a value judgment on the benefits or lack thereof of the inventions that our examiners are looking at. So they have the patent statutes, and really you apply those statutes. Now there is one of the statutes talks about being useful, but it's a very broad useful. It's not a value. Is it successful in curing X or Y? But for the most part, the value judgment component is not taken into consideration, and so something like cannabis, if it meets the statutes, the examiner will proceed and issue the patent.
Thank you. Other questions? Oh yes, there's someone in the back.
My name's Allison Hatton. I'm a patent attorney at Sanofi. And my question is for Gil, and also I think Mr. Hirschfeld could also answer. I'm wondering how you are engaging the ex-US patent offices to come to the table on some of these patent examination issues. In our experience, we've been trying to also speak with them, and I feel like the EPO in particular is a group that we've been trying to engage, and they listen, but it's not clear that they're hearing us or that there's any movement at the EPO to make similar adjustments in their examination policies.
Yeah. So from time to time, we reach out to the EPO and ask to meet, and they've accepted from time to time, and we do have.
Can you say what the EPO is for folks?
The European Patent Office.
Okay.
Yeah. So they generally will agree to meet and listen and talk. I share your sort of summary of those talks. They listen, but it doesn't always feel like they necessarily really take the feedback and make any changes. So what I've sort of told the group, if you will, is continue to have conversations with EPO examiners as they're examining your patent applications. I think my sense is that there's a little bit of a lack of connection that the European patent examiners are making between the claim scopes that they're allowing and the actual effects in the marketplace. They're sort of, I think, unaware, and it strikes me as a little odd that that's the case, given that at the European Patent Office Opposition Division, which is a place third parties can go to complain about basically inappropriately granted patents, the docket at that opposition division is chock full of innovators fighting other innovators. It's amazing actually how much activity goes on in Europe with respect to the granting of patents that sort of interfere with not just sort of the protection of the invention from a copy, but the invention from other inventions. So I don't have a magic bullet to throw out there. I just say keep trying.
Yeah, from the PTO perspective, we have routine meetings with other offices to discuss harmonization issues where topics such as this could be raised and try to understand where we can better harmonize and to get a feeling of when there's differences, what is the right path to solve those differences.
Yes.
Hi, I'm Larry Lamont with.
Here's a.
Hi, I'm Larry Lamont with Patients for Biologics Safety and Access, and but I have a question, Drew. Is with the pace of technology change in our society, how do your 8,000 examiners keep up? Because what Mark was talking about, 10 years ago, it's now like the technology changes like monthly. So I was just curious to how do they catch up, and then what do you all do to make sure that they know what is happening and can understand what is happening in the context of today?
Right. So from a pure numbers perspective, and I know you're asking more than just numbers, we have in the last, I'll say 7 or 8 years, had to hire numerous examiners to be able to keep up with the pace of applications that were being filed. We had 1 year where we hired 1,500 examiners in a single year, and you can imagine the stress that puts on the whole entire system, but we had to do so because of the increase in the number of filings that were coming in. We're now, I believe, at a size where I don't see us greatly expanding. Our plans in the next few years are basically to hire at attrition levels so that we're keeping the agency about the same size. And as examiners, I mentioned before, examiners' production systems change as they increase. So as examiners will become more advanced, they produce more work, and I believe we'll be able to stay up with the workload in that way. From a technology front, when we do hire examiners, we hire them obviously based on the particular technologies. So in, say, the biotech area, we're going to hire many PhDs, but if somebody who's examining, say, sleeves for cups, they're not going to be a PhD. So you try to match the degree, and then we try to have continuing education where it is appropriate. One of the things that we do is we either send examiners to companies or have some people from the public come into USPTO, and members of the public can actually work with companies, for example, can give demonstrations to examiners and explain technologies that those examiners see. That's been a really helpful way to keep examiners abreast of the latest technology. And remember, every application that they do, they are learning the cutting edge, so to speak, or they're learning. So just the fact of examining is going to help them learn as the technologies advance.
All right, I think we're at time. So please join me in thanking this wonderful panel. Thank you so much for joining. And thanks to all of you, both online and in the room, for joining the Bipartisan Policy Center on this important topic. So thank you, and safe travels.